Welcome, everyone. I'm Kate Kensell. The Family Law Amendment Act 2023 and the Family Law Amendment Information Sharing Act 2023 were passed by the Australian Parliament on 19 October 2023. Most of the changes to the Family Law Act commence on Monday, 6 May 2024. In this podcast, we will be discussing the key changes to family law in Australia and the impact these changes will have on lawyers. Thank you for joining me today, Professor Chisholm.
Hi, Kate. It's good to be here.
Professor Chisholm, there has been a range of changes made to the Family Law Act by these two pieces of legislation. Most, although not all, relate to the parenting framework. In brief, there are new simplified objects to Part 7 of the Family Law Act, as well as a new simplified list of best interest considerations in Section 60cc. The presumption of equal shared parental responsibility has been repealed, as has the consequences which flow from that presumption. We have a new simplified contravention of child-related orders framework, and the rule in Rice and Asplin has been legislated. Changes have been made for inclusivity of First Nation families, with a new definition of family, as well as the additional considerations in Section 60cc. We have changes to the role of the independent children's lawyer, with new obligations for ICLs to meet with children, and we have the removal of the restriction to appoint ICLs in Hague Convention matters. We also have new harmful proceeding provisions to prevent extensive litigation, and we have a new overarching purpose enacted into the Family Law Act. The framework in relation to penalties for unlawfully communicating details of family law proceedings has changed. And finally, there are new provisions for information sharing between the courts and agencies, such as the police and child protection agencies. So, Professor Chisholm, there is a lot of changes to the family law sphere. What do you think are going to be the most significant changes?
Well, the most obviously significant changes are the ones to the parenting provisions. I might just quickly comment on the other ones before coming back to those. The contravention of child-related orders provisions are essentially a clean-up job. I don't think there's any real change in substance, but it's essentially a matter of trying to make the whole thing easier to understand. The rule in Rice and Asplin, we now have a legislative version of it, which is pretty much what the case law says. There is an argument that is not quite the same, but it's very similar. The changes relating to the First Nations families are important and reflect recommendations of the Australian Law Reform Commission, and that's not an area that I'm expert in. My belief is that those changes are very welcome and uncontroversial. The ICL changes are important. In relation to the Hague Child Abduction Convention, they simply mean that the court can appoint an ICL without the previous restriction. The other provisions are much more interesting in a way, and they require ICLs to meet with children and give them a chance to be heard. Those provisions are quite detailed, and it's an interesting question how important they will be in practice. My sense is that they will be important in practice and that they will lead to ICLs taking it as their routine obligations to talk to children, give them a chance to say what they want to say, unless there are quite specific reasons not to do so. So I don't know how much ICLs currently do that. There have been some reports, although not terribly recent, suggesting that in some places, particularly ICLs, often don't talk to the children. So I think that's likely to be quite a big change. In relation to the Hague proceedings, I think it's a clearly desirable change. In both cases, there may be issues about whether the funding is adequate to enable ICLs to do the things that they now have to do. In relation to the unlawfully communicating details of family law proceedings, that's section 121, which has essentially been clarified. I don't think there's any real change there. And the information sharing provisions reflect, I think, a long period in which commentators have said that there needs to be better communication between the child protection system and the family law system. So I think they're the things that I would say about the other provisions. The parenting provisions, in a sense, the most controversial, perhaps, the one that gets people quite excited, is the removal of the presumption of equal shared parental responsibility. There are other things to say, which we'll get to, I'm sure, but the main thing about that is that under the previous law, there was a presumption of equal shared parental responsibility, and the main significance of that was that it triggered two things. It triggered an obligation on the people who have shared parental responsibility, normally, but not only the parents, to consult and make decisions jointly. And secondly, probably more importantly, it created an obligation on the court in deciding parenting matters to consider whether the child should spend equal time with each parent or substantial and there's another word.
Substantial and significant time.
Thank you. Substantial and significant time with the child. Getting rid of those consequences may well be very important, and that's a really interesting question. But in terms of parental responsibility, although people might have different views, I don't think there's much change in itself. In each case, that is, before the change and after the change, there were reasons to think that the law encouraged parents to consult about major issues, which is obviously a good thing in most cases. And if the court makes an order, then the obligation to consult essentially depends on what the order says. So that in those two ways, the law is not very different, and I would think not different at all from the present law.
In terms of those parenting changes, what do you think about the simplification of the considerations in Section 60cc? Do you see that as having a significant change on how matters will be dealt with?
Well, I think it's very good, and it does the thing that the Attorney General said it was supposed to do, and that the Law Reform Commission recommended, and that is it makes things simpler and clarifies them. The present list of things that the court has to consider is very complicated. There's a long list, and it's also complicated because some things are supposed to be primary considerations and other things are supposed to be additional considerations. Judge Grant Reithmuller wrote a wonderful article, absolutely deadpan, which was titled something like 42 Simple Steps to Deciding Children's Cases. So the big thing about the change is that it's much shorter and it's much simpler. Broadly speaking, the things that were on the list are still reflected in the present list. This is a big question, but I think that in a sense, there shouldn't be any change in outcomes, because under the new law, as under the old law, the court was obliged to treat the child's best interest as the paramount consideration. That's still the same. And the old law, apart from the presumption of equal shared parental responsibility, didn't actually say that some things were more important than others, although it hinted that that might be the case. The present law is much more straightforward. It just says, here is a list of things the court has to take into account. And I think, for the reasons that lots of commentators have said, and for the reasons that the ALRC said, that's essentially a good move. The previous list had become increasingly complicated over time and had caused people to get tangled up in the various detailed requirements, and there are some findings that it caused parents to be confused about whether the law was about them having a right to equal time with the children, or whether it was just that people shouldn't forget about equal time as a possible outcome.
And Professor Chisholm, just following up on your comment that you think in many respects the outcome of contested matters might be the same under the new simplified additional, the Section 60cc considerations. Do you think that there is a potential for the changes to substantially affect how matters are negotiated, so matters that never get to the court system?
Yes, that's the critical distinction between the effect of the law on judges when they decide cases and on people when they try and work out how to manage their parenting arrangements. I've said that it may not affect how judges actually decide cases very much. We might want to come back to that, but in relation to negotiations, really everything depends, I think, on what people think is the law when they're negotiating. That is, I assume most parents are not going to read the Act and study it, but lots of parents, I assume, especially in the contested cases, are going to get advice from counsellors and mediators and lawyers and so on about what might be good for the children and what the court might do if they don't agree. So the consequences of this legislation, I think, depend enormously on what parents think it means, and that will depend to a large extent on how they're advised. So it's very important, I think, that lawyers and advisors and all the professionals in the system have a good understanding of the legislation and what it's all about. And my view is that what it's all about is clearing away unnecessary entanglements so that everybody can just take a fresh look at what's best for the child in the particular circumstances, not feeling that they're obliged to consider one outcome or another, but that they should work out what's best for the child without any sort of artificial restrictions.
Is it fair to say then, Professor Chisholm, that perhaps the increased ability for the court to focus on the needs of a child in an individual matter would be one of a positive benefit from these changes to the family law system?
Yes, I think it is. If you boil it down and logically analyse it, as I say, you can argue that the court's decisions shouldn't actually be different, but judges are human beings, or most of them, and like all of us, we're subject to what one interesting line of research calls nudges. And so if the legislation keeps talking about that you have to think about equal time, then even though that's not a legal presumption, if you're a judge, you are going to think about that, and it's going to loom large in your mind, and it might affect the decision in ways that the decision maker is not aware of. That sort of suggestion may be particularly important in interim cases when there's not detailed evidence about what's best. So it's hard to assess. I think that judges, what I hope judges will do, and what I think they'll do, is they'll really do what the Act says and just focus on what's best for the child without all these distractions. It's a trap, I think, looking at this legislation, to think, oh, well, because the Act doesn't give the same emphasis to some things as it previously did, the Parliament is saying that those things are not important anymore. In my view, that's completely wrong.
And Professor Chisholm, do you think that there are broader social justice implications for the changes? For example, do you think the changes will help court users such as self-represented litigants?
They should. I'm not sure that it's going to be a huge difference, because I think in practice, what is going to help litigants is what resources the court has, what resources professionals have, how well they're trained, how much time is allocated for each case, and such other extremely boring intellectually, but terribly important practically things. So, but the legislation, I think, should allow the professionals and the parents to focus on the needs of each individual child, and spend less time bothering about the intricacies of the law. And if that's so, then we might expect that decisions will be more child-focused, and that I hope proceedings might be a bit shorter, because people are not distracted by having to talk about a whole lot of things that the legislation mentions but may not be important in their case. Judgments might be a bit shorter, and perhaps there might be fewer appeals because the law is not so intricate. There are quite a number of appeal cases under the previous law where you can demonstrate that the courts have got tangled up in the provisions, and that's been a point of appeal. I'm hoping that perhaps there'll be a short time where people get used to the new legislation, but once that's done, I'm hoping that the whole legal analysis, both at the trial level and at the appeal level, will become a lot simpler and more predictable.
Given the changes are imminent, what should practitioners be doing now to adapt and prepare for those changes?
Well, I should read everything I've written. They should study the legislation. There will be a lot of. I know that the Law Council is running lots of seminars. There'll be lots of information flying around about the new laws. Such of that, the sort of material that I've seen about that is good, and so practitioners really need to do a bit of work on the new provisions. Once they do it, I don't think it'll be very difficult. I think conceptually the new law is much simpler than the old law, and once the practitioners take the trouble to get on top of it, broadly speaking, I think life will be simpler. And the work they do from here on, I hope, will be much more focused on working out what's best for the particular child than tying themselves up in legal knots.
Just going back to your days as a judge, if you were a judge making a decision on the 6th of May about orders for what we call parental responsibility, and the old terminology, equal shared parental responsibility, how would such an order be framed from the 6th of May?
Well, that is an interesting question. That's probably one of the few things which is a bit arguable. But my I think what I would say to myself is, well, under another section of the Act, each parent has parental responsibility. That's the starting point. And so I would think, well, does the evidence have, is there something in the evidence that suggests that's not a good idea for this particular child? If there is, I would look at that and work out what orders should be made. If there's no such evidence or argument, I would leave the position that each parent has parental responsibility. So although there's not a presumption in the same way, there's not a presumption of equal shared parental responsibility, but there's something like a presumption that each parent should retain parental responsibility, because that's the starting point, unless there was evidence to the contrary, then a court would leave that position. I would also think about whether to say something in the order about whether the parents needed to consult about things. As I've said, if there's nothing in the order about that, then they're encouraged to consult but are not legally required to do so. If the order was that they should have joint parental responsibility, then the order would be taken to mean that they had an obligation to consult, and if they didn't, then that could be a breach of the order. So I think I would find the parental responsibility issue fairly easy to solve. I would say the starting point would be, well, is there any reason to change the existing position that each parent has it? If there is, work out whether parental responsibility should be changed in some way, whether it should be made joint, or whether perhaps one parent should have more parental responsibility than the other.
Well, Professor Chisholm, there are certainly a lot of changes for practitioners to familiarise themselves, and thank you so much for making our jobs a little bit easier and getting across these changes.
It's been a pleasure. Thank you for having me.